A dealership's relationship with its manufacturer is critically important. Communications received from the manufacturer, particularly those regarding a dealer's performance in sales, service, or customer satisfaction, can cause unnecessary complications between a franchisee and their manufacturer. While some communications are simply routine correspondence, others may contain a specific request for information or serious warnings, up to and including threats by a manufacturer to terminate a dealer's sales and service agreement. The one thing to keep in mind when dealing with any performance review communications from your OEM is to take them seriously. Understand what the manufacturer is claiming or asking for and respond appropriately after you have obtained assistance from a lawyer familiar with the intricacies of New Jersey's franchise law.
While a dealer shouldn't be overly concerned about normal marketing communications, it is important that dealers never ignore communications from the manufacturer that could potentially affect their franchises. Of particular concern are communications related to a dealer's performance, or more specifically, a manufacturer's interpretation of a dealer's performance. These performance review letters typically claim that the dealership is underperforming. Sales is the typical complaint. Another common performance standard used by franchisors to criticize dealers is the manufacturer's customer satisfaction index. So what can a dealer do when faced with a letter from their manufacturer? The first thing is to carefully read every communication you receive from your manufacturer. If it is a mundane request or aimed at a specific department, refer it to the appropriate individual in the dealership to develop a response. If it contains a claim or threat that can negatively impact your dealership, obtain legal counsel and respond swiftly and accurately. Dealers who receive performance review letters may worry that their manufacturer is laying the groundwork to build a case against them to terminate their franchise. This may be the case. Thankfully, New Jersey's Franchise Practices Act offers dealers a great deal of protection. For instance, a manufacturer has the burden to prove that its performance criteria and measurements are reasonable. The manufacturer is also required to take market conditions into consideration when judging a dealer's performance. Knowing your rights under the law is critical. If you have questions, ask the experts at NJ Carr or an attorney familiar with state franchise laws. Most manufacturers have internal appeal processes. If your franchisor is making a claim that you disagree with, you should utilize the appeal process that is available. If the results of the appeal are still unsatisfactory, you will have to decide how to proceed and whether to challenge the manufacturer in state or federal court.
Manufacturer communications are not to be trifled with. If you receive a letter that threatens your dealership, it is imperative that you respond quickly and accurately. If you are looking for more information on this subject, the National Automotive Dealers Association, or NADA, distributed a memorandum in January 2013 that provides dealers with guidance in the area of factory relations. This memorandum also provides steps dealers may want to consider when reviewing and responding to communications from their manufacturer. NJ Carr thought you should know.